I think we are ready to start. Hello, everybody. My name is Buvia Yulin, and I'm the director for SCMA. Welcome to today's webinar, Learn from the Pros, Experienced Litigators Share What Mediators Can Do to Be More Effective. This webinar is in meeting format, so you can hear and see us, and we can hear and see you, so please stay muted throughout the presentation. If you would like to just view the speakers, please make sure that you have your settings on speaker view. This virtual event is also being recorded and will be made available to all those who registered sometime next week. If you have any general questions, please feel free to either send me or Taisha a chat, or you could email us at info@scmediation.org. I will now turn it over to our programming chair and president-elect, Jennifer Toronto.
Hi, good afternoon, everyone. I want to thank you all for attending today. And I just want to take a quick moment to tell you about SCMA in case you're not familiar with our organization. We are the largest professional organization of mediators in the state of California. We put on a lot of great events, just like the one you're about to attend. If you're interested, on April 27th, we will have a webinar called The Art and Science of Podcasting, featuring Dr. Deborah Dupree and Jonah Rosenthal. Dr. Dupree has a long-time successful podcast, and Jonah Rosenthal works in the entertainment industry and will share his technical expertise. So if you're interested in starting a podcast, this is the how-to webinar. May 20th to 22nd is our Family Mediation Institute at the Hyatt Regency Indian Wells Resort and Spa, which is looking to be an excellent conference. We hope you will check out our website about all the great details, and we hope to see you there. scmediation.org if you'd like to learn more about us. I am going to now introduce our most impressive panel, and I will try to be as brief as possible. Their accomplishments are very long because they are such accomplished panelists, but I want to get to this great panel as soon as possible. So first of all, I have the pleasure of introducing Stacy Hausner. She is a full-time mediator at ADR Services. She has, since 2015, mediated over 700 cases in business, PI, personal injury, employment, real estate, insurance, construction defect, and intellectual property. When she's not mediating, she can be found teaching mediation, where she's an adjunct professor at the Strauss Institute at Pepperdine School of Law. She also trains mediators at the United States District Court Central District in their pro bono mediation program. She also teaches multiple MCLEs, coaches business people on negotiation, and educates women negotiators in the workplace. She currently sits on the ADR Executive Committee of the California Lawyers Association. Next, I have the pleasure of introducing Jeannie Harrison of the Jeannie Harrison Law Firm. She's a top women's rights lawyer handling sexual harassment, equal pay, and other employment cases. She was the lead counsel for the women of Riot Games, who secured a record-breaking $100 million settlement. Sorry about that. She was also the 2021 president of CALA, the Consumer Attorney Association of Los Angeles, the largest local plaintiffs attorney organization in the country. She has been a super lawyer for many years. Best Lawyer in America named her the 2022 Plaintiff Employment Lawyer of the Year for Los Angeles. And so we are very grateful to have her here and hear her input from the plaintiff side. Next, we have Kenneth Feldman, a partner with Lewis Brisbois, Bisgard and Smith. He's the national co-chair of their firm's legal malpractice defense group, which he has been practicing in that area since he graduated from Loyola Law School in 1987. He is one of the first certified legal specialists by the California State Bar in legal malpractice. He's a member of several organizations, including the Association of Southern California Defense Counsel. He is the lead author for a 300-page California legal malpractice and malicious prosecution liability handbook, which is now in its 8th edition. So we are very grateful to have Kenneth Feldman here to share the defense perspective. And finally, and certainly not least, we are honored to have Linda Miller-Savitt, who's an experienced trial attorney, having tried close to 100 jury trials focusing on employers and individuals sued for wrongful termination and other employment matters. She is a frequent lecturer to management groups, administrators, judges, as well as various bar-sponsored groups. Most impressively, she has tried over 100 jury and court trials, and she has numerous published decisions and recognitions, too numerous to list, but they're so impressive. I really recommend you go on our website and read through really the detailed bios of this entire panel, because this is a fabulous top-notch panel. And I just, on that note, want to thank Stacy for putting this together. We are most grateful. So welcome to all of you, and we look forward to this great webinar. Thank you.
Well, thank you so much, Jennifer, and thank you everyone for joining us here today. I feel that we are very lucky to have these experienced, renowned, excellent attorneys here today to share with us their perspectives regarding what makes a mediator particularly effective. Now, us mediators, we come into mediations with the toolbox of skills that we use to try to facilitate a settlement. And each one of us has a different style, and often these styles vary between cases. It depends upon the participants, the subject matter of the dispute, issues that may arise, and a whole bevy of other factors. One thing that can be particularly helpful for us is understanding what lawyers like and even need from us mediators to help them move their cases to settlement. So most of us know that 95% of cases settle, and oftentimes lawyers are coming to us with this one shot they have to settle their cases, and we don't want to mess this up. So let's find out from these expert attorneys what they like and what they don't like, so we can incorporate some of these insights into our toolboxes and make our settlement strategies more effective. And so without further ado, I'd like to turn it over to our panel. Thank you so much for being here, all three of you. Linda's coming in the middle of trial right now, so we're getting her on her lunch break, and I'm very appreciative of that. But let's turn it over to them and ask them some questions. And I'd like to start with a pretty broad question for the three of you. All of you have probably mediated hundreds of cases with different mediators who try different tactics to effectuate settlement. Tell us a story about a settlement tactic or a skill that a mediator has used that you found particularly helpful for resolving your disputes. And let me start with you, Jean.
So I'm going to harken back to a while ago when Lucy Barron had recently started ADR services. And I was approximately 15 years old and a lawyer. I'm kidding, I wasn't 15, but it was a while ago, okay? And it was one of my first employment mediations in a sexual harassment case. And the mediator was Judge Robert Thomas. And it was a particularly intense case. And it came to, we started at like 9 a.m. on a Friday, and we got to about 5 p.m. that Friday, and the matter had not resolved. But Judge Thomas, who has just a great personality for mediation, kept working and working and working. And I could tell that if we kept at it, there probably would be a resolution that could be reached, maybe because we weren't gone yet. And but we really had to stick with it. And Judge Thomas actually had something else scheduled that evening. And I just said straightforwardly to him, I think this is something that you can resolve, but it's going to take a lot more time. And so that is, and what he did was he actually canceled his plans for that evening. And we finally resolved the matter. And I think I went home at 3 a.m. Saturday morning. So my number one key strategy for getting cases resolved is to stick with it and to convince the lawyers for the parties that there's possibly a place where a resolution can be achieved and they need to not leave. And so if it's just way too, nobody's going to move and everybody's being unreasonable, I get it. But I think that there are times when people just give up too quickly.
Excellent. And, we talk about this at Strauss a lot when we teach as mediators to be optimistic. There are paths to settlement that may not be obvious at the outset of a mediation, and we want to stick with it and just keep trying to get over every obstacle and keep it moving towards settlement. So I love that you say that, not giving up.
To me, Stacey, it's the Peter Gabriel. Most people remember the song Sledgehammer, but off that same album, he had a song, Don't Give Up, which was a much more serious subject in mediation. But I totally agree, being tenacious, and actually kind of the converse to that would be just early on, someone coming in and giving a doomsday, this case isn't gonna settle today. I mean, we as consumers of mediators are paying a lot of dollars, or our clients are, their carriers are, to have someone there. And generally we've selected the mediator, based upon the good reputation and the like. And to me, it's gonna earn that money, that good money that we paid. And so coming in early, and kind of the same issue in terms of if it's an evaluative mediation, well, I think the case is worth X, too early, and then coming up later, that could be a problem in terms of you've got either a client from my end or a carrier who has heard at 11 in the morning, the case is worth 150,000, and at 3 o'clock I'm hearing, well, you got to pay 300,000. That wouldn't be good either. That could set the wrong tone. So I know I'm kind of jumping ahead here, but just in terms of evaluative mediators, I like that, but I like it probably more in terms of pros and cons of a case as opposed to an actual number early on.
Yeah, and the reason you said we're jumping ahead, we are gonna talk about evaluations in a little bit, but I appreciate you jumping in on that as well right now. I like that both of you are paying attention to the tenacity of a mediator, because I too think that is so important, that we try everything we can. Like, don't give up. Let's just keep it moving. Let's get past one ops. Never give up. Don't give up.
Don't give up, right?
So I'm probably the worst person to be on this panel because I've tried over 100 cases, which means I'm not settling anything. 3 cases this year. But I think you really have to really read the room. My story is the exact opposite of Jeannie's story that is so interesting. I had an individual defendant in a case. So in one sense, I wasn't the lead counsel on the defense. So I go to this mediation and it's dragging out, and the plaintiff's lawyer is dragging out. We have money, we're putting money up on the table, and it's just dragging out. And so I called my husband at 5:30 and I said, I'm gonna be late. I can't leave the mediation. And he goes, what the hell? He goes, my mother is dying and she's coming over for dinner tonight, and the only person whose food she'll eat is what you cook for her. So I said, really? What am I supposed to make for dinner? I didn't even know about this. And he goes, I want you home. I want you home. You got to fix dinner for my mother. It's pretty compelling. Okay. So I go to the mediator and say, you know what? I have to leave. I just can't do this. My mother-in-law's dying. So the mediator said, give me a minute. So she goes in there and she tells him Linda has to leave. And we settled the case in the next 20 minutes because that put the pressure on them.
Yeah,
so
exactly.
they were kind of dragging it out for the sake of dragging it out and just to agonize everybody. But when it came to like, okay, if you want to do the deal, now is the time to do it. So you have to read the room. You have to really read the room. And I do believe in tenacity. And I said, look, I'll be available by phone, but I just can't be here. No, we need you here. And that's the case settled.
Right. And this is a very true thing, that time is a pressure. And I tell people when they make an offer, it's often a good idea to have a time component to it, because at the end of the day is when cases settle, when they're out of time. And there's a lot of like literature and studies on the impact of time and when time's a scarce commodity. So Linda, you played exactly into that, which is now or never, you better get this done. So yeah, we need to be flexible. We need to read the room. We we are working for the attorneys, right? So we got to develop a process that works for the attorneys. So I think all of this is so insightful. Let me ask you this, and it's the flip side of the other question. So I think that we learn so much as mediators, or in any profession, I would imagine, from mistakes we make. So things that go wrong. So I want to ask you about that. Do you have any war stories from cases where a mediator has done something that has messed up your case and made it more difficult to settle? What advice would you give to mediators about what they should not do in a mediation?
From the plaintiff's perspective, I can tell you a couple of things. Part of what drives me crazy, and to Linda's point, is there are some mediators who, I'm sure present company accepted, but some who will just talk about themselves for, it seems like hours. And I become very anxious, and I try to steer the conversation towards the case. But I think that is particularly ineffective, and it really wastes the party's time. And I lose confidence in the mediator and their skills when I'm trying to manage that kind of scenario. The other thing that I don't think is particularly effective is when a mediator comes on really hard with a hardcore evaluation, coming at my client with that. Now that I may as well put, my client in a joint session with a defendant who's going to be, attacking them personally. It does not set up my client to be in the right mindset to work with the mediator and be open to resolution, because they just feel like emotionally battered. So those are a couple of things for me.
All right, thank you. What about you, Ken?
Yeah, I agree with that in terms of going after someone. I mean, a lot of times in legal mal policies, typically, I've never heard of one actually that doesn't contain a consent to settle provision. And if a mediator comes in like out of the box and starts laying into my client may have given the insurance carrier a blank check, basically whatever you carry, how you evaluate the case, and just coming in and beating up on a client out of the box, where the client may not have any issues like that, and it may be the carrier. So reading the room, and really that starts, so much of what we do as lawyers, and like any profession, preparation is key. And that preparation starts from, the mediator is going to get our briefs. And I know typically mediators ask for them to be a week early, but I think realistically, probably 2 business days is, given the folks who are so busy, probably not going to read it, or a couple of business. No, sometimes that pre-mediation call, a mediator may not have even read our briefs yet, but there's so much in terms of behind the scenes that you're not going to put the dynamics behind the scenes that's not going to be in the brief. And I think that's true probably of the plaintiffs and their briefs, as well as us as defendants counsel. And so understanding those dynamics before you walk in that room, be it in person, hopefully we're going to have a lot more in-person sessions, or be it virtual, that is really key. And I think understanding too, sometimes, both sides can be equally obstreperous, or both sides might come in as fairly reasonable, but doing homework is just critical in this process. So that could mess things up, and people can just dig their heels in if someone comes on too strong right at the outset. On the other hand, I will say that sometimes there are certain mediators who I feel are stronger than others, and maybe some cases I need more of a hand-holding mediator. Some I need just go after that person, because that person, just be it the opposing counsel, or be it a lot of times the opposing counsel like Jeannie, and I don't really come across Jeannie in, I'm glad to say, in legal malcases, but in terms of being an adverse counsel, but sometimes it's the counsel who can be very strident, but a lot of times it's the counsel, and I'm sure Jeannie will attest to this, needs that mediator to help her give her client realistic expectations. So sometimes I want a very hard charging mediator to be able to read the riot act to the other side if that's necessary, but just too early can really backfire.
You know, just because the both of you are talking about evaluation, then I'm going to get to you, Linda. You know, when we teach at Strauss to mediators or to lawyers and judges becoming mediators, we often say that you want to not do that. You don't want to come in with a strong evaluation right at the get-go, and that when you evaluate, you either want to do it by the request of the attorney or an arrangement you work out in the pre-mediation call, or you want to evaluate as little as possible to get past the issue. So you'd evaluate an issue, or you may evaluate a move someone makes. Like, do you think that'll encourage them to make a move? Or how about you try this move? And that you don't do that full evaluation till maybe you're trying to close the case, and you have to read it with the attorney. So I know that a lot of attorneys I've spoken to have that complaint when a mediator comes in right after reading the brief without knowing the dynamics behind all of it and comes in and is very, you know, strong-minded about what the case is worth or something like that. It can mess up their case. So that's pretty consistent with how we teach mediation. And I appreciate that you both have had that experience where that's been particularly troublesome to you. Linda, what about you?
I think the expression you just used, the dynamics of the case, is really important because every case is different. Some cases, the dynamics are the lawyers have a lot of respect for each other and they don't just hate each other. You know, there are some cases where that happens. I get it. So I mediated a case many years ago. I very vaguely remember it, quite frankly. And I was not the primary lawyer on the case. And I remember I actually flew in from a court appearance and went to the mediation late in the day. And somebody else, the lead person, was handling it. And our mediator wasn't making any progress. And it was like 11 o'clock at night. And I said, I'm sorry, I'm going over and talk to the plaintiff's lawyer. And I just burst in, went in and talked to the plaintiff's lawyer, who I had a good relationship. And I said, here are the realities. Boom, 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 boom. This is what we can do. This is what we can't do. And, you know, we're wasting a lot of time here. We got it settled in half an hour. I had another case with Jeannie Harrison. Okay. And I think Jeannie will agree. We both have tremendous respect for each other and almost use the friends word, but we're on the other side of the V. So Jeannie and I had a case a few years ago, and it happened to be an employee who was out on leave and had a disability claim and bringing him back. And everybody kind of agreed, we got to bring her back. And the mediator was going back and forth. And finally we said, let's Jeannie and me sit down and let's talk about what the problems are. Let's identify the problems to what we both agree is the solution. We came in, you know, we chit-chatted, we put our heads together, and the plaintiff was there because she said, I need this, and my sick time is, I've lost my sick time and I need bridged. And so we were able to actually figure out the deal points, and it was very effective doing it together. Now, not all cases are amenable to that. I understand that. But if you understand the dynamics of the case, there can be times when the lawyers meeting face to face is very effective. And I oftentimes tell the mediator, I don't know the plaintiff's lawyer. I'd like to go and introduce myself first thing in the morning. And I go over and say, hi, I'm Linda Sabat. I, talked to you on the phone, but I never met you. Or good to see you again. I just think it sort of takes away some of the tension and is a little disarming. And isn't that what we're trying to do at mediation? Disarm the other side.
I'm sorry. I like to do that, particularly if I have not taken a deposition of a plaintiff and have not met that plaintiff. I want to just go in that other room, look at that plaintiff, and just say hello, nice to meet you, and that's it. And generally, mediators will facilitate that for me, and typically the other side doesn't have a problem with that. I always ask my client, because I say, look, if I'm gonna go over there, likely going to ask for some quid pro quo to do the same here. Are you okay with that? But I think that can help diffuse things. And plus it just gives me at least a little bit of a first impression of someone.
I think mediators should actually recommend that. If you don't want to do a joint session, those are kind of out of vogue now, I get it. But you want me to introduce you to the lawyer? Would you like to go over and just meet the plaintiff, and it humanizes you. And so now it's not as awful of a process. That's my thought.
I love that. And I do think that as mediators, we need to be flexible. I mean, it is now expected in Southern California, at least, that you're in caucus, you stay in caucus. But sometimes getting them together, like in the situation between Linda and Jeannie, getting the attorneys together to brainstorm, or an attorney to talk to the client, the other person's client with the attorney there, really changes the dynamics in a way that allows you to avoid impasse and get to settlement. So you should be exploring this with the attorneys, what's going to work for them. I love you meeting the other client because it takes away you as the enemy type of feel. It gets us into a more collaborative tone. So I think that's fantastic. I do. I think you really help settlement when you're willing to do something like that.
Well, you have to have a Jeannie Harrison on the other side. But, it was really productive. It was really productive.
May I jump in on
Yes,
this?
please.
I think these are really important points. And I agree in general that it can be very productive for counsel to sit down and talk with one another. But what was unique and made it work between myself and Linda is that we came in with an open mind and open ears towards one another and with respect. So if we walk in and we're antagonistic towards one another, right, this would actually be something that would likely derail the mediation. Right. And so I think it's actually really important. There are some mediators also that do, just sort of routinely throw the lawyers in together. And I'm not necessarily in favor of that. I do think that it's really important for the mediator to figure out, is it appropriate in this specific case? And if it's appropriate in this specific case, let's have some ground rules. The ground rules are for everybody's benefit, that we agree that when we are in with one another, whether it's just counsel or it's counsel and clients, that we are listening and we're going to be respectful. We're going to hear each other out and not interrupt and argue with one another, but we're going to have a productive, respectful dialogue. I think it's important to set those parameters so that everybody walks in both feeling like they can trust this unique process and that they will be safe in the process. Okay. So those are my 2 cents.
Yeah, and mediators, we can never just throw them together without talking to them about it. And sometimes it requires a little coaching. Sometimes if they're really antagonistic, we do not even want to come close to going there. You get a real feel for the personality of the attorneys and the parties while we're in there. So I think that being respectful to that dynamic is really important. I love that you're all talking about this.
And again, I would say that starts with that initial call. I like it when a mediator says to me, Ken, tell me about opposing counsel. Have you had cases with him or her previously? What's your relationship to get that dynamic?
You read my mind because I was going to say this takes us into this whole pre-mediation phone call. And I think it's very important as part of the preparation. You talked about preparation too, Ken, to understand the dynamics. I want to know about the relationship between the attorneys. I want to know about the relationship between the attorney and their client. Sometimes they give me a heads up about, be careful with my client because of this or that. So I want to also give them my cell phone because now we're on Zoom, or most of them. They can reach out to me and say, Stacey, I got to talk to you without my client listening. Pull me out of the room or call me before you get into the room. We can learn about obstacles to settlement. Sometimes they'll say, look, I took the deposition of the plaintiff. She's going to be our obstacle to settlement because she has this, that, or the other thing. This gives us as mediators a big heads up. So during these phone calls, we can learn so much about the dynamics of the case and learn, maybe they don't have all the documentation. Maybe they don't have the right people coming. Maybe all of that is so important with these pre-mediation phone calls. talk to me, and I know Ken, you've been talking about this. If the other two of you have anything you want to jump in, what you like mediators to talk about, not talk about during these calls. Do you find them annoying? Do you like them like Ken does? Let me open it up to you.
So I find that they're very helpful because assuming I'm somewhat far into the case, I have a lot of insight as to what's happening. I've done a lot of discovery. I may know the history at a prior employer. I may know what's going on at the current employer besides what's happening at my case. And so I may have some insight into some hot buttons or soft spots with the other side. I also may have some insights into the lawyer. So I may be wrong, but I have what I call insight. So you should be aware of them, and then you evaluate them as the mediator, but it might give you some insight as to, how to address something. So I think it's very helpful besides just the facts, and why I think the other side actually is willing to settle the case or not willing to settle. We have one case right now where they begged us 4 times to go to mediation. And we haven't been that inclined to go for a lot of reasons, but after the 4th time, okay, we'll give it a shot, even though, we know this firm doesn't settle. But I think that's telling because they keep asking. So I think you need to know that as a mediator, that I think they're anxious.
Right. So these are the types of dynamics you wouldn't pick up in the brief. So that's great.
Right.
All right, let me ask you all this. When we mediate, we know that lawyers typically do not tell us everything. And that makes a lot of sense, right? You're looking to position your client most advantageously for settlement. What are the types of things you can tell us that you don't like to tell the mediator?
Well, I mean, from my perspective, there may be something that is really private to my client. For example, if there's a pre-litigation case. So, oftentimes I give my clients an option. Do you want to go straight to litigation, or do you want to engage in a pre-litigation effort to resolve? Because I'm very client focused, which Linda knows. I'm very client focused.
Jeannie is. Jeannie cares about her clients. She really does.
Great.
Yeah. So if we're in especially pre-litigation mediation, there may be reasons why the client has chosen not to go straight into litigation, and they want to keep certain things private to themselves. And that may be something, that was part of their strategic thinking, their reason for taking a pre-litigation approach. And so I have probably in that situation, promised that I'm going to keep that information confidential through this pre-litigation process. So it may be something that is very specific to that individual, usually for me. In my cases that I'm not at liberty to share because of my commitment to the client and the specific structure of the process and the reason why she or he has decided to go with, the process that we're in. Separately, I am pretty open, I think, any one of the mediation processes, but except for, certain information that my client may want me to keep confidential for their own reason. And sometimes it's stuff that, like, from my perspective, the whole client is the person who got hired by the employer. Now, does the employer know about all the particulars? No, but the employer didn't care to ask about all the particulars and wasn't allowed to ask about all the particulars of my client's history. So if my client has a pre-existing situation where, for example, she was molested as a child, and then her boss, her supervisor, sexually harasses her, and then she was, functioning up to that point, and then collapses and is not able to function. Like, I don't really think that I can keep that prior information separate from the case. It explains the client's breakdown. And so I try to explain to the client that we have to include that information for her reaction to make sense, right? So it's it's particular to the case from my perspective. Sorry, I went on and on giving you explanations, but that's kind of stuff that goes through my mind.
Of what to hold. What about you, the two of you? Do you have information that you typically want to hold from a mediator?
I usually don't, because I will tell them my client's motivations for wanting to settle. Sometimes I'll tell them, I have a client that refuses to settle, and you have a hard job to do. And here's why. This person's from the old country. This person doesn't believe in this kind of thing. And, I try to get my clients in the posture that they will settle, but they need an independent person explaining why. And I think I told you the story the other day when I was a mediator on a case. It was an employment case, and it was a guy who owned a trucking company, and his lawyer had got him all pumped up that he was going to win the case and get his attorney's fees. So you know how long ago this was. Well, I went back to him and I said, I went and talked to the plaintiff, and I went to talk to the defendant. I said, you know what? Have you seen the plaintiff lately? He has no teeth. He can't afford to buy dentures. Why do you think you're going to collect a judgment against this guy? You're living in la la land, but you're going to pay another $30 or $40 or $50,000 to win your summary judgment. You may not win it. It may go on appeal. You're going to spend this money anyway. Just spend this money now and be done with it. And he goes, oh, well, that's a good point. I said, yeah, you can get an award of judgment against it. You're never, ever, ever going to collect. So I was able to, and I had to work against the lawyer who had told him it was a defensible case. But so you have to, so if I have a stubborn client, I need to tell the mediator that, so they can say, let me tell you my horror stories. I tried to settle this case for 1.2 million and it didn't settle, and they hit for 7 million. Hear the horror stories. So I like to tell them that.
All right. Thank you all for that. It's been helpful. Okay, I'm going to switch us to the conversation about mediator's proposal. Now, mediator's proposal technically are supposed to be used at the end of a mediation when you have an impasse and you're either out of time or you've tried everything and the bottom lines just do not match up. Now, I've noticed that some lawyers start talking about mediator's proposal at the outset, and they seem to be positioning themselves for a mediator's proposal, even though it's technically last ditch effort when we've tried every other tool in our toolbox. How do you feel about me? Now, let me just also say for those out there that don't know what a mediator's proposal is, it is our opinion on what will settle the case. It is not our evaluation of what the case is worth at trial. It's what numbers after we've been talking all days. And we do a lot of things to try to get a good sense of that, see reactions when we throw out numbers and whatnot. Do you go into a mediation with mediator's proposal on your mind? And do you strategically plan for that? So in your communications, you're trying to get that proposal to the most advantageous number for your client? Or is this something that you're not thinking about, and at the end of the day, you say, all right, that's the proposal? What are your thoughts on that?
I generally don't walk into a mediation thinking, okay, we're going to aim for a proposal. I think that perhaps once in a blue moon, like if I just think that the parties are so far apart, but a lot of times I don't want a proposal if it's just not going to be realistic. And I think, yeah, you probably do this, Stacey. You kind of, as you test the waters, if you will. And I think most good mediators would say, look, I don't want to float a proposal unless I think there's X% pick it 75, 80 or better, that I'm going to get 2 yeses, because that could actually harm litigation down the line. So that's my attitude. I'm hoping that when I walk in, the mediator will be able to do his or her job without having to get to that point. Right. And if, again, I don't want one necessarily, if it's just going to be just way too high. I mean, sometimes I've had one where I was, wow, that's kind of low. I'd love it if the other side accepted it, but
that's not going to
I'm not so confident that that's going to happen. So that's my answer about it.
I agree with Ken. I really don't want a mediator's proposal that doesn't have a good chance of being accepted by both sides, because at that point, my client's gone through the whole day of the mediation. We haven't been able to get to a resolution. And I am very careful always, actually with every single move, to get authority from the client. So because I am never going to end up in a place where my client says, I didn't know, I didn't agree, et cetera, et cetera. So all along the way, my client has been approving each move we've made. And so my client is bought into the process and is trying, throughout the day, trying to actually do their best under their own circumstances to get to a resolution. So if they say yes, they're going to seriously consider a mediator's proposal. I want it to be something that the other side is also going to seriously consider, because otherwise I feel like I'm letting my client down by delivering something that is not taken seriously by the other side. That's how I process it.
And one time I had a mediator just said, without really discussing it with it, I'm just going to give a mediator's proposal. Forget kind of like ranges or anything. It's just, I'm going to give you a mediator's proposal. Like, what?
Right. That can be.
I don't like them. I mean, I don't look for them. I'm hoping we can get a meeting of the minds. I kind of
Me too.
am of the belief we're here to do a deal. Let's do the deal, and let's, but obviously every move everybody makes is kind of what where's the bottom line? And if it's going to take a mediator's proposal to force everybody to admit to their bottom line or top line, then it has to be done. But I'd rather us all make our moves and see if we can negotiate.
Well,
But you raised a really good point that for the defense, the settlement value of cases is what the damages are in an employment case is something for attorney's fees, or what it takes to get the case settled. And sometimes that's the hardest thing for my client to understand what it takes to get the case settled. In a med mal case, okay, it's 250 plus X. It's real simple. In an employment case, it's not that well defined. So there's a little bit of a swing on it. But I think the defense lawyers and the defendants kind of have to understand that, as do the plaintiff. If you really want to get the case settled, it may not be the number you want, but is it a good number? Can you move on with your life? Can you avoid all this stuff? So there's two values on cases anyway.
Absolutely. I appreciate that. And you brought up bottom line, top line. So that's a good transition into that. So many times in a negotiation, somebody will say, okay, my bottom line is this. And you go in the other side and they say, is that a true bottom line? And I say, well, you can test it if you don't believe it. Maybe they hang, maybe you can push it. I don't know. They're telling me it's their true bottom line. Now, as a mediator, it's an interesting thing. Like, I don't want to question someone and not take them at their word, but there is a lot of gamesmanship in negotiation. So how do you feel about that? When you tell a mediator it's the bottom line, is that really upsetting to you if they come back and say, all right, the other side gave me this as their bottom line? When you say it, do you mean, how are you dealing with this bottom line or top line conversation? And what do you like and not like from us mediators here?
Well, from my perspective, I always think that there is probably a statement by each side of, like, not going past here. And then there's a little bit either lower that the plaintiff's going to agree to or higher that the defendant's going to agree to. It always seems like there's one more sort of move that seems to happen oftentimes. I actually really agree with Linda that I would like to just get down to the bottom line at the very beginning. Yeah. Have that conversation and get to it, but I know you can't.
It's a process.
It's such a process. Sometimes it's maddening, but it's also magic. there is magic that happens.
Oh, I like that.
And so and this is why I say, you know, you really have to stick with it, because even when somebody says, this is my bottom line, and even when my client says, you know, I'm not going $1 less, if there's something that is emotionally close enough, that is probably she or he is going to change, you know, his or her mind. And that it is my job to deliver the best option that my client has to try to get the case resolved. And I'm going to let them know, like, there's nothing more. I'm being told there's nothing more, you know? And so, and sometimes we hear, no, there really isn't $1 more. There's a firm no from the other side. And I have to tell my client that, and then he or she's going to make the decision. But I think there's still always a little bit more testing, because it is the nature of the process.
I try to avoid statements like this is our top dollar, or this is the best we're going to do, unless I've mediated with someone many times and he or she knows me and I just have complete confidence in that mediator. I try to avoid those kind of statements. I remember one I had probably 10, 12 years ago where we told the mediator there were a couple numbers, and a lot of it's all psychology, and in terms of repeat business, we were getting what we thought was a really good number, and the mediator said, I'm going to do my best, or something like, try to get this for you, but they're at, I don't know, 10 or 15% more, whatever the number was, and the mediator came back in after 15 minutes to the other side and said, congratulations, we have this deal. And it was at the higher number, and we were not happy. We said, it's just like, it's just worst case worst, we'll do it. But we really weren't happy, as opposed to saying, look, folks, I really tried for you in this. I told them X, Y, and Z, and it just wasn't resonating. And I wish I could have gotten you the number, your target number. And I know you didn't want to go over it, but I got it done for that 15% more, whatever it was. But since we're talking, you know, our audience primarily would be mediators, I want the mediators to know that coming back like that with this sheer joy of excitement, we got the deal done when it wasn't really the deal and we were paying a premium. I think that message is important, conveying that message even when it is done. Along the same lines, and I'm sorry to go off topic a little bit, but if you have a deal in principle, a lot of times though, documenting that deal, I tend to bring a long form with me. I like to iron it out. I don't want to wait a month or something like that, but I want the mediator to be available to answer questions or help mediate some terms that, you know, typically in our stuff, we want a confidentiality unless my client's getting money, which happens a fair amount because lawyers often get sued because they're owed fees. And so sometimes it could be my client getting money back and not paying anything. Or if the amount we're paying is just so nominal, typically we want a confidentiality. And I try to put that in up front. The mediator should know that, like with professionals, typically confidentiality provision is going to be there. But we don't want the mediator just to disappear, right. At least make herself available to resolve impasses.
I love when you bring long forms and they're ready to go. First, it gets you in the collaborative, let's get this case settled mindset, but also it allows us to stay engaged. A lot of us mediators have short form agreements. On Zoom, it's very easy to stay engaged as you're going back and forth with the documents. But I appreciate you bringing that up because I do think it's not over just because you agree on the number. We have other provisions that we have to make sure we're
think Yogi Berra, not over till it's over, right?
Exactly.
So I never say this is the last, best, and final unless I really, really mean it. But right. This is something I think that actually goes to the heart of mediation. Nobody believes you if you have made 27 moves, you know, of $5,000 each, because, you know, and the biggest frustration in mediation, someone told me this, don't hang the meat so high the dog won't jump.
Yeah.
Okay, the plaintiff's demands are like ridiculous demands. And the defense comes back with, well, $1,500.
Yeah.
Okay, so you're gonna waste 4 to 7 hours bridging this gap. And so I think a real mediator's job should be to try and get both sides to give realistic numbers. Kind of goes to the point, Ginny and I like to get to the point, but realistic numbers, not fantasy land numbers. And because they won't believe you they're not going to believe you when you start at $1,500. So they're not going to believe you when you say $7,500, that's my best, last and final offer. So everyone's got to be realistic. And I think that's where a mediator needs to put a lot of emphasis. Okay, they're not going to pay you $5 million. So don't start at $5 million. You're not showing a sign of weakness by starting at a more reasonable number. In fact, you're showing you want to do a deal. And if you hang the meat reasonably low,
The dog will jump.
The dog will jump.
Yeah, I love, Linda, that you're bringing this up, because this is what us mediators face a lot. Somebody comes in with a ridiculously big opening demand, and in response, defense is sending the message, I don't like your number, I'm coming in low. So one's at 5,000, one's at 2 million. And then it's time to make the next move and everybody drops or moves by 5,000. Now, we're not in real numbers here. We're in the insult round, right? It doesn't, but everyone's scared to move to a reasonable number because the other one, is still at these extreme insulting numbers. So none of
I know, but I got to tell you, if the defense actually sees that they're being reasonable, I think the defense will say, oh, okay, maybe we can get this done. And maybe we have to throw in an extra 10,000 or an extra 25,000, but we'll get it done. They're not inclined to do that when you start at ridiculous numbers.
Right. So we are trying to get everyone to engage in productive negotiating behavior. So we don't want to be hanging out at these big numbers. Now, we have lots of tools in our toolbox, to get people to come in at better numbers, to make bigger moves. And that we spend a lot of that. I believe in mediators being very active in coaching this negotiation stage, so it doesn't peter out like you're talking about, Linda. So I love that you're bringing this up. Now, one tool that mediators can use is these brackets, because everyone's scared to get off their extreme position, but they're willing to talk reasonably if the other side's willing to talk reasonably. So they're willing to go to 500,000 if the other side's going to come up to 300,000. And now we're in this reasonable range. Once cases get in the reasonable range, they tend to settle. They really do, because everyone's seeing a gain here. Now, one thing that mediators do is these brackets to create this. Now, so many lawyers tell me, I don't like brackets. I'm not doing brackets. We end up being in the bracket just 2 hours later if they won't let us be in the bracket, but I'm doing everything to try to get everybody in this range, and nobody wants to make the move unless the other side's getting in the reasonable range. What are your thoughts on this? What are your thoughts on brackets? What are your thoughts on this very active negotiation coaching? To get it so that the mediation doesn't die before it gets started. We got to I always say, you got to hang the meat low enough that the dog will jump, right? If you're at extreme numbers, the defense doesn't have to be thinking about it. That's not where the magic happens. Talk to us about that, everybody.
I like an active mediator who's really trying to figure out where is a range that this could potentially get settled. Now, I will tell you that from the management of the perspective of managing the plaintiff, I do everything I can to manage the plaintiff's expectations. And I have very good relationships with my clients. Before getting into mediation, there are some times when I also represent, some very, intelligent and accomplished professionals who have their own ideas about what their case is worth, right? And so even though I've been working through that with them, they still need to hear that kind of thing from the mediator. And I still need to start in a range that, you know, where my client has buy-in even just to begin the process, right? So that is a dynamic that does happen, and I'm sure it happens on the defense side as well, right? And then it's the mediator's job, and it's important for them to do this, to really actively coach and work the parties, even though they emotionally need to start off at these range or these, you know, numbers that aren't going to be productive at that moment. So I very much endorse active, you know, management by the mediators to the extent that it makes sense. There are some times when, you know, parties are just so, you know, intractable that it's not going to matter. But I think that it's very important for a mediator to do. And I definitely agree with using brackets. There are times when they're really useful. So
if I could jump in, Ken, before you speak, because I got to sign off. I got to get back to
Of
work.
course. Good
But
luck.
I hate the word midpoint. Okay. I hate the word midpoint because all of a sudden this bracket, this range that's supposed to be amorphous has got a fixed number in there. So get off the word bracket. That's all I have to say about
I think,
get off the word
that's
midpoint.
great. I think that we don't have to say bracket. We can say, if you move to here, what if I can get them to move to this number if you move to this?
I think Linda's point is like, if it's, you come
I
in.
gotta go.
okay,
I'm sorry. I gotta
Sure.
go.
Good luck,
I'm so
Linda.
sorry.
Thank you.
Bye. I loved doing this. Bye.
Thank you for
Good
joining.
luck. So we heard the numbers 500 and 300. So then you got a midpoint of 400. And I think brackets have their place. If we have these extreme numbers to begin with, I think then the mediation lends itself more to having brackets. They are a very useful tool, but you know, I've seen negotiations on the brackets too. Okay, whether it's 500 and 300, or I might say, well, no, the top dollar will be 350 and the bottom will be 100 or something like that in response to that. So there's always that kind of negotiation potential that's out there. Sometimes the initial bracket, which may be proposed by the mediator, is palatable. That's okay.
Mediators, you get a lot of information when they start negotiating brackets. If you're looking at the end of the day, a proposal, or you're going to do a hypothetical offer, and you're getting a sense, and they're getting a sense from each other, we can get this case settled around these numbers. We don't know specifically, but it can be settled. So it creates that type of optimism that makes like Jeannie hang in there till 3 a.m., right? Where she sees, okay, this might be settleable. When she's hearing about these brackets. Let me ask you real quickly, because I know we're running out of time. Selecting a mediator. How do you select us? What do you look at? What's important to you?
So it's funny because when we were preparing, Linda said that she likes to have the plaintiff's lawyer, you know, offer up some names because she wants the plaintiff's attorney to feel confident about the mediator. And I didn't jump in and say, Linda, you're stealing my move. But I usually ask the defense counsel for names because I have a pretty high measure of confidence in my case selection and my case workup. And so I need the defense counsel and the defendant to have confidence in the mediator, because I feel like I'm going to be able to be persuasive in the presentation of my case. So seems like we do that on both sides, but most importantly to me, I'm not interested in a mediator who's just, you know, shuttling the number back and forth,
Right.
And who's not value added. That's a waste of my time. And so I really want somebody who is going to, you know, be evaluative and helpful, not, you know, overbearing and turn off my client, but a productive individual, and who is going to assist with actually moving people into a productive range.
Right. I had a case which involved kind of a difficult measure of damages. And the mediator came in, and the mediator is quite experienced and gave our side, well, this is how I calculate the damages. And we tended to like that calculation, but it's, okay, well, did you share that with the other room? And if there's going to be a calculation like that, it would seem to me that there would be a sharing. But back to your point, Stacy, in terms of selection. So from my perspective, the beauty of representing lawyers is I see the gamut, so many different practice areas. There might be certain areas that are more prone to being sued than others. Plaintiffs, personal injury, wills and trusts, family law, you see a lot of it, and of course conflicts, but just in general. But so I oftentimes, and depending upon the size of the case, want someone who has a particular expertise in the underlying. If it's an entertainment case, I might want someone who has that entertainment background, who can speak that language. That's important to me. The notion of age or gender, that can have a role. I'll ask my client, okay, your former client is an older gentleman. Do you think he would respond well to someone very young like Stacy, who's not that young anymore, right? But conversely, just would a younger plaintiff respond to someone really old? And I since my client is going to know his or her former client better than me, I want that input. And a lot of times it doesn't matter so much, but at least that goes into my thinking. And I like the notion of, I say, give me 5 names. I feel with 5, as long as they're based. I mean, I go to Orange County and sometimes I'll go, I had a case up north recently, but if we're talking LA County case and the other side is going to give me the names of 5 mediators, I figure either I know that mediator and work with them, or given the size of my firm, I'm comfortable that, yes, okay, I'll get, Ken, that person's good and we'll be okay.
And
All right.
my last point on that is just, I agree with Ken about somebody who knows the area of law. With regard to employment, it is complex and ever changing. And so a failure to understand the law will really inhibit a person's ability to be effective in an employment mediation.
Yeah, and I actually had one time who was actually a very well-known, good employment mediator, but in the legal mal world, besides breach of duty, there's the notion of causation. And it was a little challenging to get the mediator to understand, just because my folks blew a statute doesn't mean there's automatic liability. You have to prove the case within the case. So that notion, there are certain kind of go-to on the legal mal side. Just one last thing, Stacy, for me, kind of near and dear to my heart, that I would feel remiss that I didn't mention, which is just insurance. And that's very, very important in terms of understanding the dynamic. Is there a reservation of rights, meaning is the carrier here, like in a malicious prosecution case, those policies provide for, we usually win them actually at the outset on the anti-SLAPP motion, but in that rare case where we don't, there's really no indemnity right or something like that. So, and then also the notion of burning limits policies and the like. So mediators need to be very familiar with the way insurance works in these situations, and understand that certain insurance folks who might be former attorneys who really miss mixing it up, they might be very active. And that's, again, the benefit of calling someone like me up front. And I may say, look, I've got so-and-so, she's going to be very involved in this mediation, whereas others may just completely defer to me. But ultimately, the mediator should reach out to the lawyer. When I've got a carrier, or Linda's got a carrier, talk to the lawyer first, but then you'll read the room and see how it is.
Right. The insurance adds a whole nother dynamic here. So we do need to make sure, in the pre-mediation calls, I think we have to make sure we understand what the issues are with insurance, what the coverage issues, and all of those issues you just raised, Ken. It is a whole nother dynamic that us mediators need to prepare and make sure we're understanding the policies involved. So I appreciate you bringing that up. I wish I had another hour to speak to you. I have so many questions unanswered, and I think that you give us so many insights as mediators. There's so much that I know we teach and we talk about and we think about, and to have your perspective on it, I think is so insightful. So I appreciate you taking the time. I know I've been given the signal that we're out of time, and I really don't want to take any more of the two of your time. So I really appreciate you being here with us, and to all of you out there that have joined us in the meeting, thank you so much for being a part of this today.
Thanks for
Thanks
having
for
us,
having me.
Stacey. And right, just what, I don't know the ultimate outcome, but I understand something special is happening in the Dodger game today. So there you go. All right.
And thank you, Stacy and Jeannie and Ken, and also thank you to Linda. What a wonderful panel. Thank you everyone for attending.
Thank you, everybody.
Thanks for
Have a
having
great
me.
day.
Bye-bye.
Bye-bye.